Sarah, I can't breathe it.
That's on you.
The Sarah Boone case has a lot of confusing and interesting issues that her defense is going to need to navigate. I'm Lainey Law.
And I'm attorney Andrew Myers.
So a couple of points in this case stood out to me, and I'm sure this case has stood out to a lot of people because it has a lot of unconventional issues going on. I brought Andrew with me here today to kind of help navigate some of these questions that I have. With Sarah Boone, my first question for you, Andrew. How is drinking going to impact the second-degree murder charge? So, if you're drinking, can you really say that it was of ill will? Can you argue that because you're drinking that the person was inhibited and they didn't actually know what was going on?
Well, here's why I think it was brought down to second-degree murder and not first-degree murder. And I'm going to talk about the drinking, but we have to back up. The difference between first-degree murder and second-degree murder is that first-degree murder is with a premeditation and deliberation. Even though those things can, in fact, happen in a second, it does require malice of forethought, something that goes through the defendant's mind to make them have the intent for first degree. And the formation of that intent, sometimes it's days or weeks, sometimes it's a couple of seconds, but there is what the law calls mens rea, a mental state. So the way drinking comes into it is the prosecutors probably said that she was intoxicated, that she had been drinking, that negated her mind from forming the requisite intent for first degree. So that's why they brought it down to the second degree, which is still an intentional unaliving, but it doesn't have that. So my guess, and I've said it before, I'm not inside the heads of the prosecutors, but I'm guessing that that's why it's second degree. Now, can Sarah Boone's defense say, oh, well, she was drinking, so that, no, that's a much tougher row to hoe. If that's what your question is, that would be a really tough thing legally for them to argue.
Sarah, I can't breathe it.
Oh, that's what I feel like when you drink on me.
Our second question, and I guess because this has a lot of aspects to it, because, her defense is going to have to really fight through the fact that she filmed some level of this crime where, hopefully, hopefully not, our viewers have seen, but I know our viewers have probably seen already the video where he's saying, I can't breathe, and she's kind of sitting there laughing. Do you really think that there's any type of way that the defense is going to be able to get around that, where you already have someone laughing on videos and, maybe she felt at risk, but if you have someone laughing and seeming like they're okay, how do you think this filming is going to impact the case?
Well, it's already impacted the case because, her initial defense, as I understand it, was they were playing around. They were just fooling around, and she passed out upstairs in her bed. And so she had no intent that anything bad happened. And then she just woke up the next morning and he was gone. So the fact that she filmed the whole thing on camera, the video that you just mentioned, that he was inside the suitcase and said he couldn't breathe and begging her to let him out, obviously that pretty much fries her goose in this case, except, her attorneys, I'm sure, in their zealous representation of her, and give me all the hate you want down below, and let me know what you think. But her attorneys or her new attorney, number 9, will have to bring a motion to suppress that and to try and keep it from the jury. That motion will not be allowed because all you have to do to allow something like that into court is authenticate it and show that it is what it purports to be. And it's going to go in. It's going to go into evidence. So it's, in my mind, that's going to be a really tough thing for them to explain away.
I definitely agree with you on that. I don't see any universe where that's not going to be brought. Now, How now this one was a little bit interesting to me. I was curious on what Jorge's background, how this is going to impact them, because they've seemingly had, you know, altercations in the past. There's been violence in the past. Does it help her, or will they be even able to bring it into the case that he has this criminal history? Are they going to be able to say, look, he was a criminal, she was scared, he was violent, it was a dangerous situation? Do you think that something like that is going to come into play here?
Well, under the rules of evidence, there's such a thing as a trial within a trial, and Mr. Torres is not on trial, post his passing. And so the fact that he, there was some DV between the two of them, the fact that he had criminal offenses against him, really, is that relevant, or is it more prejudicial? And that's, I don't know. That's, the other way of looking at this is, how does that really explain Sarah Boone's behavior? I said that in the other episode, that if she was fearful for her life, if she thought that he was quote unquote a bad person. First of all, the question is whether the court would even allow this in. There are going to be all kinds of motions to suppress and motions in limine to keep evidence out before the trial. So that's one question, whether it would even come in. But then the next question is, I hate to say this, but so what? So what? Does that entitle her to unalive him? No, of course not. She certainly had other options. If she was certainly in fear for her life, which is her new defense, I understand, although this is very fluid right now. Things could change between now and tomorrow. But if she really was in fear for her life, wouldn't she have had other options? Couldn't she have called a friend? Couldn't she have wheeled the suitcase out into the street, locked the door, called a friend and said, hey, get Jorge, get him out of here, don't let him inside, or other options? I don't know. So yeah, I don't think that it's not a pretty picture, but I don't think it's really going to help her.
I think you did a really good job answering that question, bringing up that bringing the background into the case may cause prejudice. Not only that, but if somebody is a criminal, like, so what? Like, does that give you the right to commit a crime against that? And no. I think that's a good answer in that case. Number 4. We are on attorney number 9, if you haven't lost count already. Now, this I kind of already feel I know the answer to, because, the jury, this is presumably something that the jury is not going to be aware of. No. But now, because with the jury selection too, I'm wondering if it could be argued that, say, the jury has heard of the case, because with the Kohberger case we've been talking about, well, just because the jury is aware of the case doesn't mean that they're counted out. So in a situation where they're interviewing someone and the jury knows that there have been a lot of attorneys, do you think that's going to be reason to dismiss them as a juror because they have the prejudice? And, I'm going to ask the obvious question here as a secondary question to that. There's no way that this information is going to be made public to the jury, correct?
Oh, of course not. No. Of course it wouldn't be made public to the jury. It's a procedural thing that occurred before the actual trial starts. And as we're seeing in the Kohberger case, we've focused on a lot in the past. A lot of stuff happens procedurally before the real trial. They argue about venue. They argue about evidence. They argue about witnesses. They argue, about experts. They argue, about the DP. So, no, pretrial stuff is not going to be relevant. But the other way to look at it is that, and in the Kohberger case, we just went through an entire day and I got nasty comments down below. People said that I was being flipped when they tuned in and they wanted a legal analysis. And all I was saying was that it was interminable and too long. But we had a whole day long of some of the evidence was really interesting about confirmation bias and about, the effect of seeing media in your mind, and jurors say, oh yeah, I could ignore that and be fair. Can you really? Are we really wired, even though a lot of people say, oh, yeah, I can be, despite having read, seen, and heard about her having 9 attorneys, I can still be fair. But the question is really, can jurors Can jurors, can some of the brouhaha that has surrounded this case from day one? I mean, you know, I mentioned before, I watched a lot on court TV about this case. They did a good job, like but that's available to everybody in the jury pool. And so, yeah, it's a good question that they might well have heard about all of this, and it might well be in the back of their minds, and they might well during voir dire say, oh yeah, I can still be fair. But can they?
It's crazy. I mean, I think, I think the majority of our audience watching this may already have some type. I mean, I'm curious to see if there are any commenters defending Sarah, because in my head, I feel like a lot of the publicity that's come out makes it kind of like, okay, like this person is uncooperative, this person is combative, this person has had so many attorneys. But I definitely want to hear if anybody in the comments is actually pro Sarah and can kind of give an argument there, because I'm interested in hearing it. Now, my last question for you today is about the battered women defense. And so this is, I think I already know the answer to my question in this case again, but I want to hear your opinion on it, because one of the new arguments is, oh, she's a battered woman. We discussed earlier the background with the violence, but we also have some videos where I've seen some of the commentators kind of be, say like, oh, she doesn't have her story together. She's adding pieces here and there. Some of our viewers may be familiar with the 911 call videos of Sarah, where we have some police body cam where the police are going in and saying, what happened? Oh, he was calling me names. When did he call you names? Oh, after he hit me. Wait, did he hit you? It's like in the call, you said you hit him back. Oh, I didn't hit him back. And kind of just going back and forth. So do you think that they have a case with this, using this battered woman defense? And I think I know the answer to this, but are things like those 911 police body cam videos going to be part of this case, or is that prejudicial?
There's a lot of layers to that. I mean, the fact that she changed her story and a statement of a party is admissible. So the fact that she gave various statements at various times, sitting there in the interrogation room, giving one story and then later on giving another story, and the facts of the case not bearing up, those all hurt her. I mean, if they could bring an expert in, and say that she was diagnosed with symptoms from the syndrome, and that it obviated her ability to know the difference between right and wrong. That's one route the defense could go down, that she was so severely the victim of DV that she had lost touch with reality and didn't know the difference between right and wrong, and therefore bring an insanity type of a defense. That's one road they could go down. But with the limited time before preparing for the trial, it's tough. So it would take a lot of skill to bring that defense. And, I hate saying wait and see, but it would just be a tough road. That's all I can really say.
Mm-hmm. And I guess you touched on something that now I'm curious about. You mentioned like a diagnosis. So if they wanted to argue that, she's suffering from battered woman syndrome, they would need a professional to diagnose her on that, correct?
Oh, absolutely. You need expert testimony, because, any what they call a lay witness is only allowed to testify as to their observations and the facts. Lay witness is not allowed to give an opinion. And so to diagnose anyone with anything, whether it's a car accident where somebody, suffered a back sprain, you need an expert testimony to say that they suffered, in my opinion, to a reasonable degree of medical certainty, they suffered a back sprain to a reasonable degree of medical certainty. And it was causally related to a car accident. So if we have to go through all of those gesticulations in a simple car accident case, imagine the evidence and the expert testimony and the procedural path that's required in order to do that. I'm not saying it's impossible. I'm not saying it's a bad idea. I'm just saying anybody that wants to go down that road has their work cut out for them.
Mm-hmm. And so thank you, Andrew, for answering all my questions today. As a layman myself, I go through these cases and there's some things that kind of stand out to me. I think you have a pretty good comprehensive knowledge of the law, which, given your profession makes sense. So I do want to thank you for answering this. You have any final words for our viewers at home?
I would just like to ask people what they think is going to happen in this case. We get all kinds of comments, and I do read them. I read the comments, and I'm just wondering, I've seen a lot of coverage of this case on court TV or elsewhere, and I've read a lot about it in the papers. And I would just like to, know if, every criminal defendant is entitled to a presumption of innocence. And I do respect that as a working attorney still. I respect that fully and totally and completely. And I could go off on a tangent on that, but I won't. I think a lot of people are shaking their head on this case. I think a lot of people are shaking their head. So especially on that last point that you made, I'd like to hear what people down in the comments section say. A, what do you think about this case? And B, what about battered women's syndrome? What about that? So give us your comments.
Yeah, definitely. I want to hear everybody's comments, but especially if you are Team Pro Sarah. I feel like every time in the media that we hear about this, it's always people being like, no, she's crazy. Oh, she's had so many attorneys. But I would really love to hear from someone who is on her side. So if you have that, or, maybe you don't think that she's innocent, but you still want to play that argument, definitely be sure to leave it down in the comments down below, and I will let Andrew take us to the grocery store.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.